I will drag you out of this garage by your hair if you don't start walking. The words bounce off concrete pillars and die somewhere in the fluorescent hum of level 2. A woman stands between a gray sedan and a white pickup truck, her hand frozen on the strap of her leather bag. She is black, mid-40s, wearing a cream blouse tucked into navy slacks. No jewelry except a thin watch. No makeup except a trace of lipstick applied in the dark of 5:48 a.m. The man who spoke is 6'2", florid, with a neck that strains against his collar. He blocks the path to the elevator. Behind him, a woman with ash blonde hair clutches a designer purse to her chest like a shield. Her lips move silently, rehearsing something. The black woman does not step back, does not raise her voice, does not reach for her phone. She says, "I'm walking to the elevator. You're in my way." The man, Garrett Hollister, though she does not know his name yet, laughs. It is not a pleasant sound. It is the laugh of someone who has never been told no by a woman who looks like her. "You don't belong here," he says. "This is courthouse parking. Authorized personnel. You see a sign anywhere that says loitering permitted? I see a sign that says court visitors and authorized personnel, 6 a.m. to 9 p.m. I'm a court visitor. It's 7:14 a.m. His wife, Bryn, 52, the kind of woman who sends back salads, steps forward. Her voice carries that particular pitch of performed fear. "Garrett, she's not leaving. Call security. I'm calling 911. The black woman watches Bryn's fingers move across her phone screen. She notes the time, 7:15. She notes the slight tremor in the wife's hand. Adrenaline, not fear. She notes that the husband has moved closer, close enough that she can smell coffee on his breath, close enough that his shadow falls across her face. Somewhere 3 floors above them, a courtroom sits empty. The nameplate on the bench reads, Judge Marlene Ashford. But that is a detail that will matter later. Right now, in this garage, Marlene is just a black woman who parked in the wrong space. Bryn Hollister's 911 call connects at 7:16 a.m. The recording will later be entered into evidence as Exhibit 7A, authenticated by Miami-Dade Dispatch Supervisor Linda Chen. Call identification number 7422019. The relevant portion reads as follows. Dispatcher, Miami-Dade 911, what is your emergency? Caller, there's a black woman in the courthouse parking garage, level 2. She's acting suspicious and she won't leave. My husband is trying to... Dispatcher, ma'am, slow down. Is she threatening you? Caller, she's standing there, aggressively. She won't tell us why she's here. We asked her nicely, and she has an attitude. Can you send someone? She might be casing cars. Dispatcher, is she attempting to enter any vehicles? Caller, not yet, but she's looking around. You know how they do. Please, we don't feel safe. The call lasts 2 minutes and 14 seconds. During that time, Marlene Ashford does not move, does not speak, does not give them anything they can use. She waits, and 3 floors above, her courtroom waits too. The morning had started the way all of Marlene Ashford's mornings started, in silence. 5:48 a.m. No alarm. Her body simply knew. 12 years on the bench had trained her better than any clock ever could. She rose in the dark, made coffee with precisely 2 tablespoons of grounds, and drank it standing at her kitchen window while the sky shifted from black to gray. Her clothes hung in the closet exactly as she had arranged them the night before. Blouse on the left hanger, slacks on the right. Shoes aligned beneath, toes pointing forward. It was a habit she had developed long before law school, back when she was the daughter of a career Army sergeant who believed that discipline started with your dresser drawers. She dressed without turning on the overhead light, applied lipstick by feel, gathered her files, 3 pending motions, a sentencing memorandum, 2 case summaries, and arranged them in her bag in order of docket number. She did not need to check. She always knew. By 6:22, she was in her car. By 6:51, she was approaching the courthouse. By 6:53, she discovered that the judge's reserved lot was blocked by a construction crane and 3 trucks bearing the logo of Hollister & Sons Commercial Contracting. She circled once, twice. The construction foreman waved her away without looking up from his phone. Fine, public garage it was. She parked on level 2, space 247, and sat for a moment with her hands on the wheel. The garage was quiet. A few cars scattered across the concrete like afterthoughts. The elevator hummed somewhere in the distance. She gathered her bag, checked her watch, 7:12, and stepped out of her sedan. That was when she noticed the white pickup truck 3 spaces down. That was when she saw the couple inside watching her through the windshield. That was when the woman pointed and the man's door swung open. And that was when everything went wrong. If you've ever been judged before anyone knew your name, you already know what comes next. Stay with me. Garrett Hollister had not planned to confront anyone that morning. He had planned to arrive at the courthouse, plead no contest to a speeding ticket, pay his fine, and be back at the job site by 9. Simple, clean, the kind of minor inconvenience that men like him erased with money and moved on from without memory. But then he saw her, a black woman, alone, in a parking garage at 7 in the morning, moving slowly, checking her surroundings, carrying a bag that could hold anything. His wife saw her too. "Garrett, look at her. She's casing cars." He watched the woman walk toward the elevator, confident, unhurried, like she belonged. That was the part that bothered him. Not her presence, her confidence. "I'll handle it," he said, and he believed he would. Marlene saw him coming before he reached her. She had spent 12 years reading body language from the bench. The nervous defendant, the lying witness, the attorney about to lose his temper. She knew what aggression looked like before it announced itself. This man was announcing himself loudly. She adjusted her grip on her bag, shifted her weight slightly back, kept her face neutral. "Excuse me." His voice was the kind that expected attention. "You need to leave. I'm sorry. This garage is for courthouse personnel. Authorized people. You need to leave." She looked past him to the sign mounted on the concrete pillar. White letters on blue, Miami-Dade County Courthouse Parking Structure, open to authorized personnel and court visitors between 6 a.m. and 9 p.m. Violators subject to Florida Statute 810.09, trespass. "I'm a court visitor," she said, "within posted hours." Court visitor. He repeated it like she had said something absurd. What kind of court business? The kind that's none of your business. Behind him, Bryn made a sound, half gasp, half scoff. The performative shock of a woman who had never been spoken to directly by someone who looked like Marlene. "Garrett, she's being hostile." "I'm being clear," Marlene said. "There's a difference." Garrett stepped closer, close enough that she could see the veins in his neck, close enough that his shadow fell across her face. "Let me make something clear to you," he said. "My company built half the structures in this county. I know every judge, every clerk, every security guard in this building, and I have never seen you before. So either you show me some ID, or I make one phone call and you're explaining yourself to the police." Marlene felt something cold settle in her chest, not fear, something older, something she had learned to carry at 7 years old when a store clerk followed her through the aisles, something she had refined at 22 when a law school professor asked if she was there to clean, something that had calcified into armor by the time she took the bench and defense attorneys questioned whether she could be impartial. She let the silence stretch. Then she said, "I'm under no legal obligation to present identification in a public parking structure. The posted notice permits court visitors. I'm a court visitor. That's the extent of what I owe you." Her voice did not rise. Her hands did not shake. She spoke the way she spoke from the bench, measured, precise, final. Garrett's face darkened. "You think you're smart," he said. "Reading signs, quoting rules. You think that makes you belong here? I don't need to belong. I need to get to the elevator. You're in my way." She stepped forward. He did not move. The shove happened at 7:17 a.m. Marlene would later describe it in her incident report with clinical precision. "Subject grabbed my left arm above the elbow, twisted, and pushed me backward into the concrete pillar behind space 24. The back of my head made contact with the pillar. My bag fell. My files scattered." What she would not describe, what she would never put into words, was the sound of her skull against concrete, the hollow thud that seemed to echo through the empty garage, the ringing in her ears that lasted longer than she expected. She did not fall. She caught herself against the pillar, one hand flat against rough concrete, the other still clutching her phone. Her files lay scattered across the garage floor, manila folders, a leather planner, her reading glasses, one lens cracked. Garrett stood over her. "Now," he said, "are you going to leave, or do I need to help you?" Marlene looked at him, at his flushed face, at his raised hand. At his wife standing 10 feet back, phone pressed to her ear, already speaking to someone. 911, security, it didn't matter. She unlocked her phone with her thumb. "What are you doing?" Garrett's voice sharpened. "Calling 911. My wife already called. They're sending someone. Then there will be 2 calls." Her finger found the numbers. "Mine will have a different story." She pressed dial. The phone rang once, twice. "Miami-Dade 911, what is your emergency?" "I'm in the courthouse parking garage, level 2, near space 247. I've just been assaulted by a white male, approximately 6'2", 220 pounds, wearing a blue polo shirt. He shoved me into a concrete pillar. His wife is present and has called 911 with what I expect will be a contradictory account. My name is..." Garrett lunged. His hand closed around her wrist, squeezed. "Hang up," he said. "Hang up the phone." On the line, the dispatcher's voice crackled. Ma'am, are you still there? Can you describe your location?" Marlene kept her eyes on Garrett, kept her voice steady. "I'm still here. The subject is now grabbing my wrist. I am not resisting. I am standing still. I need an officer dispatched to my location." "Ma'am, stay on the line. I'm dispatching a unit now." Garrett released her wrist like it burned him. "You're lying," he said. "You attacked me. Bryn saw it. She'll tell them what she wants them to believe." Marlene lowered the phone but did not end the call. Whether they believe her is a different question. The elevator chimed. All 3 of them turned. The doors opened. A man stepped out, khaki uniform, badge on his chest, the word security stitched above his pocket. Marlene read his name tag, Corso V. She read his expression, decision already made. He looked at Garrett, looked at Bryn, looked at Marlene, standing against a pillar, files scattered around her feet, phone in her hand. He walked toward Marlene. "Ma'am," he said, "I'm going to need you to step over here." Vincent Corso had been courthouse security supervisor for 11 years. He had seen everything: drunk defendants, crying families, attorneys who threw punches in hallways. He had learned to read situations in seconds and resolve them in minutes. This situation read clearly. White couple, well-dressed, the man's face red with righteous anger. Black woman, disheveled, files on the ground, clearly the instigator. "Ma'am," he repeated, gesturing toward the far wall, "step over here while I sort this out." "I've already called 911, the woman said. "My call is logged. I'd like to make a formal report." "We'll get to that. First, let's separate everyone and calm down." "I'm calm. I've been calm. I was assaulted while standing in a public parking structure." Corso glanced at Garrett, at Bryn, at the files scattered across the ground. "Sir, can you tell me what happened?" Garrett's voice came out controlled now. Reasonable. The voice of a man who understood how these things worked. "We were walking to the courthouse when we noticed this woman behaving suspiciously, checking cars, looking around. My wife felt uncomfortable, so I approached and asked if she needed help. She became aggressive, hostile. When I tried to de-escalate, she grabbed my arm. I defended myself." "That's not what happened," Marlene said. Corso held up a hand. "Ma'am, I'll take your statement in a moment." "You'll take it now, or you'll take it from the officers when they arrive. No one needs to involve police in a simple misunderstanding. It's not simple, and it's not a misunderstanding." Marlene's voice did not rise, but something in it shifted, hardened. "A man assaulted me, grabbed my arm, shoved me into a pillar. His wife called 911 and reported me as a suspicious person. I have a bruise forming on my arm and a possible contusion on the back of my head. That's not a misunderstanding. That's battery under Florida Statute 784.03. Corso blinked. Garrett shifted his weight. Bryn's grip tightened on her phone. Something passed between the 3 of them. Husband, wife, security guard. Something Marlene recognized. The silent recalibration of people who had underestimated their target. "Ma'am," Corso said, his voice careful now, "let's not make this bigger than it needs to be. I'm not making it anything. I'm describing what happened. Whether it becomes big depends entirely on how you respond." She bent down and began gathering her files. One by one, methodical, unhurried, as if she had all the time in the world. Garrett watched her. His hands opened and closed at his sides. "This is ridiculous," he muttered. "Bryn, let's go. We have a hearing." "Sir," Corso's voice stopped him. "I'll need you to wait until I've documented the incident." "Document what?" "She attacked me.
You have a bruise forming, sir. Garrett's face went very still. That's what I thought. Corso turned back to Marlene. Ma'am, I'm going to need your name for the report. She straightened. Her files were gathered. Her glasses, cracked lens and all, were back in her bag. Marlene Ashford, she said. Ashford. And you're here for court business? I am. What kind? She met his eyes, held them. The kind I'll discuss with the officers when they arrive. The officers did not arrive. Corso's body cam, badge number 4417, footage later retrieved under discovery, recorded what happened next. Timestamp 7:22 a.m. Corso. Dispatch, this is Corso at level 2 parking. Situation is code 4, handled, no unit needed. Dispatcher, copy that. Canceling dispatch. The call lasted 8 seconds. Marlene heard it. She heard him cancel the response to her 911 call. She heard him decide that whatever she had experienced did not warrant police involvement. You canceled my dispatch, she said. I assessed the situation. It's handled. It's not handled. I was assaulted. I want to file a report. You can file a report with courthouse administration. 3rd floor. I'll note the incident in my log. Your log. Yes, ma'am. She looked at him. At his face arranged in professional neutrality, at his hand resting on his radio, at the way he had positioned himself, between her and the Hollisters, yes, but also between her and the elevator, not protecting her, containing her. I'd like your badge number for my records, she said. It's on my uniform, ma'am, 4417. And your supervisor's name? Something flickered in his eyes, the first sign of uncertainty. That would be Captain Torres, but I don't think... Thank you. She adjusted her bag on her shoulder. I'll be filing a formal complaint. You'll receive notice. She walked past him, past Garrett, who stood frozen, his face unreadable, past Bryn, whose phone hung loose at her side. She pressed the elevator button. The doors opened immediately. She stepped inside, turned, faced them all. By the way, she said, you should know something about the sign you cited. Florida Statute 819 requires posted notice and refusal to leave. I was never asked to leave until you demanded it, and by then you had already committed assault. The doors began to close. Have a good day in court, she said. The last thing she saw was Garrett Hollister's face. He looked like a man who had just realized he might have made a very expensive mistake. The thing about bullies is they only remember what they did when it's too late. Keep watching. The 3rd floor of the Miami-Dade County Courthouse smelled like old files and fresh anxiety. Marlene walked past the metal detectors, nodded to the bailiff, who waved her through without checking her bag, and turned left toward court administration. Her head throbbed, a low, persistent pulse at the base of her skull where it had struck the pillar. She would need to have it checked. Later, after she filed the report. The intake office was a beige room with fluorescent lights and a counter staffed by a woman in her 30s. Her name tag read, Nadine Polk, Administrative Specialist. Good morning, Marlene said. I need to file an incident report. Nadine looked up. Her eyes moved across Marlene's face, her rumpled blouse, the scuff on her sleeve. What kind of incident? Assault. In the parking garage, approximately 20 minutes ago. Nadine's fingers hovered over her keyboard. And you are? Marlene Ashford. Something shifted in Nadine's expression, a flicker of recognition, quickly suppressed. I see. And you're visiting the courthouse today? I'm attending to court business. Which courtroom? That's not relevant to the incident report. Nadine's mouth thinned. Ma'am, these reports can get complicated for everyone involved. Are you sure you want to proceed? Marlene felt the cold thing in her chest grow colder. I was assaulted, she said. I have a bruise forming on my arm and possible head trauma. A security supervisor canceled my 911 dispatch without taking my statement. I am absolutely certain I want to proceed. I'm just saying, I know what you're saying. Marlene leaned forward slightly. I'm saying something different. Date of incident, today's date, time, 7:17 a.m. Location, level 2 parking structure, near space 247. Assailant, white male, approximately 6'2", 220 pounds, blue polo shirt. His wife was present and made a false 911 report. Security Supervisor Vincent Corso, badge number 441, canceled police dispatch and failed to take my statement. I want all of that documented, Nadine typed, slowly. her fingers moving across the keys with the enthusiasm of someone filling out their own termination paperwork. "And what exactly do you allege happened?" "I don't allege, I'm reporting. The male subject grabbed my left arm, twisted it, and shoved me backward into a concrete pillar. I struck my head on impact. My belongings were scattered. I called 911 during the assault." "Did you provoke the confrontation in any way?" Marlene's hand flattened on the counter. "I walked toward an elevator while black. Is that what you mean?" Nadine's face went red. "I have to ask these questions. It's standard." "Then ask them. But write down my answers exactly as I give them. I did not provoke. I did not escalate. I was standing in a public parking structure, holding my bag, walking to an elevator. I was stopped, accused of trespassing, and assaulted when I declined to present identification." Nadine's typing grew faster. "I'll need your contact information for follow-up." Marlene provided it. "Phone number, address, email, and your connection to the courthouse? For our records?" Marlene paused. In her mind, she saw two paths. The first, reveal her position, watch Nadine's face change, watch the entire machinery of the courthouse shift into damage control mode. The second, remain silent, see how far the system would go to dismiss her. She chose the second. "I'm connected to court business," she said. "That's sufficient for your records. Ma'am, when can I expect confirmation that this report has been filed?" Nadine hesitated. "Reports are reviewed by the administrative supervisor within 72 hours. You'll receive written confirmation after that." 72 hours. "Standard procedure," Marlene straightened. "I understand standard procedure," she said. "I also understand that security footage in the parking structure auto-deletes after 72 hours. Administrative Order 2014, Section 4B. If that footage is not preserved before deletion, I'll be filing a supplemental complaint for spoliation of evidence." Nadine's mouth opened, closed. I'll flag it for immediate review." "Please do." Marlene turned and walked out of the office. Behind her, she heard Nadine pick up the phone. "Captain Torres, this is Nadine in admin. We have a situation." The situation was about to become significantly more complicated. 47 minutes after the assault, Judge Marlene Ashford took the bench in courtroom 6A. She had stopped in the judge's private restroom to examine her injuries. The bruise on her arm had darkened to purple, 4 distinct marks where Garrett's fingers had dug in. The back of her head was tender, but not bleeding. She would file a medical report later, with photographs. For now, she had a docket to manage. She slipped into her robes, black, familiar, armor of a different kind, and entered the courtroom through the rear door. "All rise," the bailiff announced. "The 11th Judicial Circuit Court of Miami-Dade County is now in session. The Honorable Marlene Ashford presiding." She took her seat, arranged her files, looked out at the courtroom. Attorneys shuffled papers. Defendants sat with their families. A court reporter positioned her hands over the stenotype. Normal. Routine. Another Tuesday morning. Except for the bruise hidden beneath her sleeve. Except for the incident report sitting on Nadine Polk's desk. Except for the man named Garrett Hollister, who was, at that very moment, sitting in courtroom 4B, waiting for his traffic hearing, utterly unaware that the woman he had shoved into a pillar was now wearing judicial robes 3 doors down. Marlene called the first case. "Matter of State versus Williams. Is counsel ready to proceed?" The morning began. In courtroom 4B, Garrett Hollister fidgeted in the hard wooden chair. His traffic hearing was scheduled for 8:30. It was now 8:47. The judge, a balding man with glasses and a voice like gravel, was working through cases with the speed of a glacier. Bryn sat beside him, scrolling through her phone. "I still can't believe that woman," she whispered. "The nerve! Talking to us like that. Drop it. I'm just saying, she was clearly disturbed. Did you see how she reacted? Total overreaction." Garrett said nothing. He was replaying the moment in his mind. The way she had stood there, calm, unafraid. The way she had quoted the statute. The way she had looked at him when the elevator doors closed. Something about it bothered him, not guilt. Garrett Hollister did not feel guilt about confronting suspicious people in parking garages. He felt righteous, protective. He had been protecting his wife, protecting the courthouse, protecting the natural order of things. But something about the way that woman had looked at him... "Hollister," the court clerk called. "Garrett Hollister, matter of traffic citation 24 TC 4411. He stood, adjusted his tie. walked to the defendant's table. 20 minutes later, he pleaded no contest, paid his $400 fine, and walked out of the courtroom with Bryn at his side. "That was painless," Bryn said. "Let's go home." They walked toward the lobby, past the metal detectors, past the security desk where a different officer sat. Not Corso. Bryn paused at the bank of monitors on the wall. 6 screens, each showing a different courtroom. Channel 7 courthouse feed, playing silently. "Garrett." "What?" "Look." She was pointing at monitor 3, courtroom 6A. A woman in black robes sat at the bench, reviewing papers. She looked up briefly, straight into the camera, before turning to address someone off-screen. Garrett felt his stomach drop. That's her. From the garage? That's her. Holy cow, that's the woman from the garage. He grabbed Bryn's arm and pulled her closer to the monitor. The chyron at the bottom of the screen scrolled past. Marlene Ashford presiding, motion hearing, docket 24 CF 1127. "Honorable," Bryn whispered. "She's a judge?" Garrett did not answer. He was watching the woman on the screen, the same woman who had stood in front of him in a parking garage, wearing slacks and a cream blouse, holding a leather bag. The same woman he had grabbed by the arm. The same woman he had shoved into a concrete pillar. The same woman who was now wearing judicial robes and presiding over a courtroom. "We need to leave," he said. "Now. Garrett, now." They left the courthouse at a near run. Behind them, on monitor 3, Judge Marlene Ashford continued her morning docket. She did not know they had seen her, not yet. The news reached Marlene at 11:42 a.m. She had just finished a suppression hearing, defendant's motion denied, evidence admitted, when her judicial assistant knocked on her chamber's door. "Judge Ashford, there's a Vincent Corso from security here to see you." Marlene set down her pen. "Send him in." Corso entered the chambers like a man walking into a minefield. His earlier confidence was gone. In its place was something that looked almost like fear. "Judge Ashford," he said, "I didn't realize, this morning in the garage, I had no idea who you were. And if you had," he faltered. "Would you have taken my statement?" Marlene asked. "Would you have dispatched a unit? Would you have treated me differently if you had known I was a judge? That's not... Because I'm curious about your answer, Mr. Corso. I'm curious whether you're telling me that your treatment of victims depends on their professional status. Because if so, that's a troubling admission." Corso's face had gone pale. "I came to apologize," he said, "for any misunderstanding." "There's no misunderstanding. There's an incident report on file. There's a request for footage preservation. There's a 911 call with your voice-canceling police dispatch. Judge Ashford, I'm not speaking to you as Judge Ashford. I'm speaking to you as Marlene Ashford, victim of battery, whose complaint was dismissed by a security supervisor who made assumptions about her credibility based on her appearance." Corso stood very still. "What happens now?" Marlene leaned back in her chair. "Now? Now you go back to your post. You wait for internal affairs to contact you. You retain counsel if you think it's warranted. And you think very carefully about how you document this conversation in your personal notes, because I'll be documenting it in mine." He left without another word. 3 hours. That's how long it took for the system to start protecting itself. But she wasn't done, not even close. Summer. The Hollister's attorney was named Delmore Vance. He was 54, Yale Law, partner at Holland & Associates, and he had built a career on making problems disappear for clients who could afford discretion. Garrett Hollister had been his client for 12 years, contract disputes, zoning issues, the occasional aggressive negotiation that required legal cleanup. This was different. "You assaulted a sitting judge," Vance said, closing his office door, "in a courthouse parking garage, with your wife as a witness who called 911 to report the victim as suspicious." Garrett sat in the leather chair across from Vance's desk. His face was gray. "I didn't know who she was. That's not a defense. That's an aggravating factor. You assaulted a black woman because you assume she didn't belong. That she happened to be a judge makes your liability worse, not better. What do I do?" Vance sat down, steepled his fingers. "First, we get ahead of this. I'll file a motion in your traffic case, preserved on the record, claiming that a courthouse visitor engaged in provocative conduct that caused you to respond defensively. It won't win, but it creates an alternative narrative. Will that work? It will muddy the waters. Right now, the only account in the official record is whatever she told the intake officer. We need a competing story. Bryn's 911 call is a disaster. She described a black woman standing aggressively. That's going to play very badly in front of any jury, any judge, any reporter who gets hold of it. Garrett's hands gripped the armrests. So what do we do? Vance smiled. It was not a reassuring smile. We do what we always do. We make this complicated. We make it expensive. We make her decide whether pursuing this is worth the scrutiny. She's a judge. She deals with scrutiny every day. She's a judge who was assaulted while walking to work in plain clothes. She filed a complaint with courthouse administration, not the police. She's being careful, strategic. That means she has something to protect. What? Vance leaned forward. That's what we need to find out. The next 48 hours unfolded with the slow inevitability of a system protecting its own. At 2:17 p.m. on the day of the assault, Vance filed his motion, matter of State v. Hollister, case num. 224 TC 4411, motion to preserve evidence. The motion alleged that a courthouse visitor engaged in threatening posture and verbal escalation, necessitating reasonable defensive action by Mr. Hollister. The motion named no one, but it did not need to. At 4:44 p.m., local news station WSVN ran a headline. Courthouse altercation, both sides claim assault. The story was thin, no names, no details, but it included a description. Black woman, late 40s, professional appearance. At 6:18 p.m., Nadine Polk left a voicemail on Marlene's personal phone. Judge Ashford, this is Nadine from admin. I wanted to let you know that your incident report has been flagged for review. Captain Torres will be in touch. Captain Torres did not call. At 9:12 p.m., Marlene received an email from an address she did not recognize, dvancehollandlegal.com. Subject line, re, Hollister matter. The email was not addressed to her. It was forwarded, accidentally or intentionally, impossible to say, from a chain between Vance and someone whose name had been redacted. The visible portion read, if she's courthouse staff, we can argue selective enforcement. Discovery should be interesting. Marlene read the email 3 times. Then she called her former law school classmate, Patricia Okonkwo, who had left the bench 5 years ago to practice civil rights law. Patty, I need a favor. Name it. I was assaulted this morning, in the courthouse garage. The man's attorney is already filing motions. I need someone to preserve evidence before it disappears. Silence on the line. Then, you want to file suit? I want options. I want someone who isn't afraid of discovery. You know what this will mean, for your career, for your privacy. I know exactly what it will mean. Another silence, longer this time. I'll file the preservation request tonight, Patty said. Administrative Order 2019-14. Footage auto-deletes after 72 hours. We have until Friday morning. The attack was Tuesday. That gives us 53 hours. I'll have it done in 24. Thank you. Marlene, Patty's voice softened. Are you okay? Marlene looked at her arm, at the bruise that had darkened from purple to black, at the 4 finger-shaped marks that would photograph beautifully for an evidence file. I will be, she said. She hung up, and she began to prepare. Wednesday morning, 40 hours since the assault. Marlene arrived at the courthouse at her usual time, 6:22 a.m., but she did not go to the parking garage. She parked 3 blocks away in a public lot and walked. The reserved judge's lot was still blocked by construction. Hollister & Sons, commercial contracting. She noted the irony, did not smile. Her chambers were quiet. Her judicial assistant had not yet arrived. She sat at her desk, opened her laptop, and began to build her file. First, photographs. She removed her blouse, stood in front of the mirror on the back of her door, and documented the bruise from multiple angles. Left arm, anterior view, left arm, lateral view, close-up showing finger impression. She uploaded the images to a secure folder, time-stamped automatically by the system. Second, the 911 call. She had requested a copy from dispatch, standard procedure available to any complainant. The recording arrived in her email at 7:14 a.m. She listened to it twice. Her voice on the recording was calm, precise, professional, the voice of someone who had done this before. Third, Corso's body cam. This would require discovery. Patty had filed the preservation request. The footage would be held until the matter was resolved, but viewing it would have to wait. Fourth, the email. Vance's forwarded email sat in her inbox like a confession. If she's courthouse staff, we can argue selective enforcement. Not if she's innocent, not if she was wrongly accused. If she's courthouse staff. The assumption baked in, of course she was guilty of something. The only question was how to leverage it. She printed the email, placed it in her file. Fifth, prior complaints. This would require a FOIA request, public records of any previous complaints against Security Supervisor Vincent Corso. She drafted the request, addressed it to the Office of Public Records, and saved it for filing. Sixth, medical documentation. She had scheduled an appointment with her personal physician for 1:15 p.m. The examination would be documented. The findings would be photographed. The chain of custody would be established. By 8:45, her file was organized. Her evidence was preserved. Her next steps were clear. Her judicial assistant knocked on the door. "Judge Ashford, you have a visitor. Chief Judge Briley." Marlene closed her laptop. "Send him in." Thurston Briley had been Chief Judge of the 11th Circuit for 9 years. He was 67, silver-haired, and possessed of a gravitas that filled every room he entered. He had mentored Marlene when she was a new judge. He had recommended her for appellate panels. He had written glowing performance reviews that sat in her personnel file. He was also, at this moment, asking her to make the whole thing disappear. "Marlene," he said, settling into the chair across from her desk, "this garage situation, it's unfortunate. Unfortunate. A man lost his temper. A misunderstanding escalated. These things happen. A man assaulted me. In our courthouse. That's what happened." Briley spread his hands. "A man shoved a woman he didn't recognize. In a parking garage. At 7 in the morning. Where anyone might be." The words hung in the air. "Where anyone might be," Marlene repeated. "You mean where anyone black might be, and might be questioned, and might be assaulted, because she didn't look like she belonged? That's not what I'm saying." "It's exactly what you're saying." Briley's expression shifted. The avuncular mentor faded. Something harder emerged. "I'm saying that pursuing this will create a spectacle, media attention, discovery, depositions, your name in the papers, your past cases scrutinized, defense attorneys looking for any angle to claim you're biased. Is that what you want? What I want is to do my job without being assaulted in the parking garage. And you can. This can be resolved quietly. Hollister makes a donation to a charity of your choice. His attorney drafts an apology. Corso receives a written reprimand. Everyone moves on. And the next black woman who walks through that garage," Briley paused. "What about her? The next woman who parks in the wrong lot. The next visitor who doesn't look like she belongs. What happens to her? Marlene, because if I accept a quiet resolution, I'm telling Corso that his assumptions were acceptable. I'm telling the Hollisters that $400 and an apology letter is the price of assaulting a black woman. I'm telling everyone who works in this building that their safety depends on their professional status, not their humanity." She stood, walked to her window, looked out at the Miami skyline, at the construction cranes that dotted the horizon, at the world that kept building itself without asking who got crushed beneath the foundations. "I filed an incident report," she said. "I've requested preservation of the security footage. I've submitted a FOIA request for prior complaints against Corso, and I've retained counsel." Behind her, she heard Briley exhale. "You're making this personal." "It became personal when he grabbed my arm. You're going to war with the institution you serve." She turned to face him. "I'm holding the institution accountable to its own standards. There's a difference." Briley stood. His face was unreadable. "I hope you know what you're doing," he said. "I hope you're prepared for what comes next." "I've been preparing for this my whole life," she said. "I just didn't know it until Tuesday morning." He left without another word. The first document arrived on Thursday afternoon. It was delivered to Marlene's chambers by courthouse inner office mail, a manila envelope with no return address. Inside was a single sheet of paper, a photocopy of a personnel file, heavily redacted, but one section was visible. Complainant, redacted, black female, age 34, courthouse visitor. Incident date, March 14th, 2023. Subject, Security Supervisor Vincent Corso, badge number 4417. Allegation, discriminatory treatment during routine security screening. Complainant alleges subject made comments regarding her appearance and questioned her presence in judge's chamber's waiting area despite valid appointment. Disposition: insufficient evidence of discriminatory intent. Recommendation: verbal counseling, no formal discipline. Signed, redacted, HR Director. Marlene read it twice. Then she turned the paper over. On the back, handwritten in blue ink, there are two more. Ask the right questions. No signature. She sat very still. Someone inside the courthouse, someone with access to HR files, had sent her this. Someone who wanted her to know that Corso had done this before. Someone who wanted her to ask questions that would lead to more complaints, more victims, more patterns. The question was, who and why now? The faux IA response arrived Friday morning, 51 hours after the assault, 21 hours before the footage would have auto-deleted. 3 prior complaints against security supervisor Vincent Corso, all from Black courthouse visitors, all marked resolved, no action. March 23, the complaint from the anonymous envelope, verbal counseling. August 23, a Black attorney alleged that Corso demanded additional identification beyond what was required. Investigation inconclusive. January 24, a Black defendant's mother claimed Corso physically blocked her from entering a courtroom where her son's hearing was taking place. Complainant withdrew after receiving written apology. 3 complaints, 3 dismissals, 3 Black women whose experiences had been filed away and forgotten, until now. Marlene assembled the documents in her file, the FOIA response, the anonymous photocopy, the email chain, the 911 recordings, the incident report. And then she noticed something, the August 23 complaint, the Black attorney who had been asked for additional identification. The attorney's name was partially visible, blacked out but not completely obscured. Marlene held the paper up to the light. She could make out 4 letters, O-K-O-N, Patricia Okonkwo. Her former law school classmate, her current attorney. Patty had filed a complaint against Corso 18 months ago. Patty had never mentioned it. Marlene called her that afternoon. "Why didn't you tell me?" Silence on the line. "Patty, I read the August 20 complaint. OKON. You filed against Corso 18 months before he dismissed my complaint, and you never said a word. Would it have changed anything?" "It would have told me I wasn't alone." More silence. Then, "I didn't tell you because I was ashamed. I'm a civil rights attorney. I fight these cases every day, and when it happened to me, I let it go. I let them tell me it was inconclusive. I let them bury it. Because I didn't want to be the woman who made trouble. You're not making trouble now. I'm helping you make trouble. That's different." Patty's voice hardened. "And Marlene, there's something else." "What?" "The anonymous envelope you received, the HR file. I don't know who sent it, but I have a guess." "Who?" "Someone who's been keeping track. Someone who's been waiting for the right case, the right complainant. Someone inside the courthouse who can access personnel files without leaving a trail." Marlene thought about it. Who had access? HR staff, administrative supervisors, judicial assistants. "Do you have a name?" "Not yet, but I'm looking." A pause. "Marlene, whoever sent that envelope is taking a serious risk. If they're discovered, they lose their job. Maybe worse. They're doing this because they believe in what you're doing. Don't let them down." "I won't." She hung up. And she looked at the documents spread across her desk. The complaints, the patterns, the system protecting itself. Someone inside that system had decided to help her. The question was whether that someone could be trusted, or whether they were setting a trap. The second anonymous delivery arrived Monday morning. This time, the envelope contained 3 items. First, an email printout, dated 6 months earlier. Sender, Vincent Corso. Recipient, redacted. Subject, Incident Protocol. The visible portion read, "Standard approach. Let them file the complaint. Let them feel heard. Then mark it resolved and move on. Nobody reads the archives. Nobody cares about patterns. We just need to make sure the right people never see the wrong files." Second, a handwritten note on courthouse stationery. 4 words, "The right person is watching." Third, a business card, plain white, no name, just a phone number, and 2 words printed in small black letters. Internal Affairs. Marlene stared at the business card. Someone was guiding her, step by step, complaint by complaint, building a case not just against Corso, but against the system that had protected him. The question remained, who, and what did they want? She picked up her phone, dialed the number. It rang twice. Internal Affairs, Investigator Osei speaking. This is Judge Marlene Ashford. I received your card. A pause. Then, Judge Ashford, I've been expecting your call. Renata Osei was 41, Nigerian-American, and had spent 14 years investigating corruption in law enforcement agencies across South Florida. She had joined the Judicial Qualifications Commission 3 years ago after a case involving a sheriff's deputy who had been extorting defendants' families. She met Marlene at a coffee shop 2 blocks from the courthouse. Neutral ground, no recordings. I didn't send the envelope, Renata said before Marlene could ask, but I know who did. Who? Someone I've been working with for 18 months. Someone who's been documenting Corso's pattern long before you walked into that garage. A source, a witness, multiple witnesses actually, but none of them willing to come forward. Until now. Marlene set down her coffee cup. What changed? You did. Renata leaned forward. Judge Ashford, do you understand what you represent to the people who work in that courthouse? To the clerks, the bailiffs, the administrative staff who've watched Corso operate for years? You're a sitting judge. You have power, protection, a platform. If you file a complaint and it gets buried, that's one thing. If you file a complaint and it leads to accountability, that changes everything. I'm one person. You're a symbol, the right person in the right position at the right moment. Renata paused. The question is, are you willing to be used? Used how? I've been building a case against Corso for 2 years. 3 complaints on file, yes. But there are at least 7 more that were never officially reported. Women who were too afraid, too discouraged, too beaten down to put their names on paper. If you pursue your complaint aggressively, publicly, they might come forward. They might finally feel safe enough to speak. And if they don't, then you're alone. One judge against a security supervisor with 11 years of seniority and a union that will fight to protect him. Marlene thought about it, about the bruise on her arm, about the email chain from Vance, about Briley's voice telling her to make it all disappear. What do you need from me? Renata smiled. It was not a triumphant smile. It was the smile of someone who had been waiting a very long time. I need you to keep pushing. File the formal complaint with Internal Affairs, request a disciplinary hearing, make enough noise that the other witnesses feel safe coming forward. And in return, I make sure your complaint doesn't get buried. I make sure the right people see the right files. I make sure the pattern becomes impossible to ignore. Marlene picked up her coffee cup, took a long sip. The anonymous source, she said, the person sending the envelopes, are they safe? For now, but if this goes public, that changes. They'll have to make a choice. What choice? Renata's eyes met hers. The same choice you're making, whether to stay hidden and survive, or to stand up and hope the system doesn't crush them. The formal complaint was filed Tuesday afternoon, exactly 1 week after the assault. Marlene delivered it personally to the Internal Affairs office on the 5th floor. The intake officer, a young man with nervous hands, accepted the documents without meeting her eyes. This will be reviewed by the assigned investigator, he said. You'll receive notice of the hearing date. When? Standard timeline is 60 to 90 days. That's unacceptable. He looked up, startled. The security footage has been preserved, Marlene said. The witnesses are identified. The pattern of complaints is documented. There's no reason for a 60-day delay. Ma'am, Judge Ashford, that's just how I know how it works. I also know that expedited review is available for cases involving clear evidence of misconduct. Florida Administrative Code 60L 36.005. I'm requesting expedited review, the intake officer swallowed. I'll note that in the file. You'll do more than noted. You'll forward it to Investigator Osei with my request for a meeting within 72 hours. He typed something on his computer. His hands were shaking. Done, he said. Marlene turned and walked out. Behind her, she heard him pick up the phone. Investigator Osei, we have a situation. The situation was about to become significantly more complicated. Thursday morning, 11 days after the assault. Marlene was reviewing case files in her chambers when her judicial assistant knocked. "Judge Ashford, you have a visitor, Attorney Delmore Vance." She set down her pen. Vance, the Hollister's attorney, the man who had filed the provocative conduct motion, the man whose email had been conveniently forwarded to her inbox. "Send him in." Vance entered with the confidence of a man who believed he was about to win. He was well-dressed, well-groomed, and carrying a leather briefcase that probably cost more than most defendants' cars. "Judge Ashford," he said, "thank you for seeing me. I didn't invite you, you showed up." "Fair point." He settled into the chair across from her desk, uninvited. "I'll be brief. My clients are prepared to make this go away." "Your clients assaulted me." "My clients had an encounter with a woman they didn't recognize, an encounter that escalated, an encounter that both sides now regret." "I don't regret anything," Vance smiled. It was the smile of a man who had practiced it in mirrors. "Judge Ashford, let me be direct. You've filed an internal affairs complaint. You've requested preservation of security footage. You've retained counsel, Patricia Okonkwo, I believe, who has her own history with Mr. Corso. You're building toward a public confrontation. I'm pursuing accountability. You're pursuing embarrassment for yourself, for this courthouse, for the institution you've served for 12 years. He leaned forward. "What do you actually want?" "I want the man who grabbed me to face consequences. I want the security supervisor who dismissed my complaint to face consequences. I want the system that enabled both of them to change. And you think a public hearing will accomplish that? I think silence accomplishes nothing." Vance nodded slowly. "What if I told you that my clients are prepared to make a significant donation to a civil rights organization of your choice? 6 figures, anonymous, no connection to this incident. What if I told you that Mr. Corso has agreed to early retirement, effective next month? What if I told you that the chief judge has already drafted a policy memo on implicit bias training for courthouse security?" Marlene felt the cold thing in her chest grow colder. "You've already talked to Briley." "I've talked to everyone, Judge Ashford. That's my job. And everyone agrees that this can be resolved quietly, cleanly, without spectacle, without accountability, with discreet accountability. Corso retires, my clients donate. You receive a private apology. Everyone moves on." She stood, walked to the window. "Mr. Vance, do you know how many black women have filed complaints against Vincent Corso in the past 3 years?" Silence. "At least 7, probably more. Women who were questioned, dismissed, humiliated, and then told their experiences didn't matter. Women whose complaints were marked resolved, no action, and buried in personnel files that nobody reads." She turned to face him. "If I accept your offer, I'm telling those women that their experiences still don't matter. I'm telling them that money and retirement packages are the price of institutional racism. I'm telling them that even a sitting judge can't change anything. You're being idealistic." "I'm being accurate." Vance stood. His smile had faded. "Then I suppose we'll see each other at the hearing." "I suppose we will." He walked to the door, paused. "One last thing, Judge Ashford. Discovery works both ways. If this goes forward, my clients will be entitled to examine your record, your cases, your decisions, any patterns of bias, any reversals on appeal, anything that might suggest that your judgment is compromised. Is that a threat?" "It's legal process." He opened the door. "Good luck." He left. And Marlene sat very still, thinking about what he had said. Discovery works both ways. They were going to look for something, some weakness, some vulnerability, some case she had decided wrong, some ruling that could be challenged, some pattern that could be spun into doubt. They were going to try to destroy her credibility. She picked up her phone, called Patty. "We need to review my case history, all of it, every ruling, every appeal, every complaint, before they do." "What happened?" "Vance just threatened to dig through my record." Silence. Then, "I'll start tonight." The first crack appeared 3 days later. Patty called at 7:44 p.m., her voice tight. "Marlene, we have a problem." "What kind of problem?" "State v. Morrison, 20. You denied a motion to suppress evidence in a drug case. The defendant was black. His attorney filed an appeal claiming racial bias in your ruling. The appeal was denied." "Yes, but the attorney's brief is still on file, and it includes a quote from your ruling that taken out of context, sounds what? Sounds like you said that the defendant's race was relevant to the probable cause determination. Marlene closed her eyes. I said that the defendant's description matched the witness's description, which included race as one of several identifying characteristics. That's standard Fourth Amendment analysis. I know what you said, but Vance doesn't care about context. He cares about headlines. And black judge cited race in criminal ruling is one hell of a headline. So, we get ahead of it. How? We release the full ruling, the full context, before he can cherry pick. That's risky. It makes it look like you're defensive. I'm not defensive. I'm accurate. There's a difference. Another silence. There's something else, Patty said. What? The Morrison appeal, the attorney who filed it. What about him? He's dead. Car accident. 3 months after the appeal was denied. Marlene felt something cold move through her. And his files were transferred to his firm, Holland and Associates. Holland? Delmore Vance's firm. The cold thing spread. Are you saying Vance had access to the Morrison file before he threatened to dig through my record? I'm saying it's a hell of a coincidence. The second crack appeared 2 days after that. An email arrived in Marlene's personal inbox. Not her courthouse account, her personal address, the one she used for family and old friends. Sender, unknown. Subject, you should see this. Attachment, one PDF file. She opened it. It was a photograph of a document, a single page, yellowed with age, a case file from '97. The header read, Circuit Court of Miami-Dade County, case num 97 CF 2247. Defendant, Ashford, Marcus L. Charge, possession with intent to distribute, disposition, guilty, sentenced to 8 years, Marcus Ashford, her father's brother, her uncle, who she had last seen at a family gathering when she was 16 years old. Her uncle, who had disappeared into the prison system and never returned. Her uncle, whose case file was now sitting in her inbox, sent by someone who wanted her to know they knew. She stared at the photograph. Someone had done their research. Deep research. The kind of research that required access to decades-old court records and the potions to connect family trees. Someone wanted her to know that they could hurt her, that they could reveal a family member's criminal record, that they could spin a narrative. Black judge with convict uncle. How impartial can she really be? It was a warning shot, and it had come from inside the courthouse. Marlene did not sleep that night. She sat in her living room, lights off, staring at the photograph on her phone screen. At her uncle's name, at the charge, at the 8-year sentence that had erased him from her family's life. She thought about the morning she had learned he was gone, her father's face, closed, ashamed, refusing to speak of it, her mother's quiet tears. The way the family had simply moved on, as if Marcus had never existed. She had been 16. She had not understood. Now she was 47, and she understood perfectly. The system that had taken her uncle was the same system she now served, the same system she was trying to hold accountable, the same system that was now threatening to use his memory against her. She picked up her phone, opened her contacts, found a name she had not called in years. Her father answered on the third ring. Marlene? It's after midnight. What's wrong? Dad, I need to ask you about Uncle Marcus. Silence. Long, heavy silence. Why? Because someone is using his case against me, and I need to know if there's anything else. Any other secrets. Any other things that could be found. More silence. Dad, please, he exhaled, a tired sound. The sound of a man who had carried something heavy for a very long time. Your uncle made mistakes, he said. We all did, but what happened to him, that wasn't just his mistakes. What do you mean? The officer who arrested him, the prosecutor who charged him, the judge who sentenced him. What about them? They're all dead now. Doesn't matter anymore. It matters to me. Another exhale. Your uncle was set up, Marlene. The drugs weren't his. He was holding them for someone, a friend, he thought, someone who turned out to be an informant. The whole thing was a sting operation that went wrong. Marcus took the fall because nobody believed him. Nobody wanted to believe him. And you never told me. What was I supposed to say? That the system your daughter wants to serve destroyed her uncle? That the robes you wear were worn by a man who sentenced an innocent person to 8 years? Marlene's hand tightened on the phone. Who was the judge? Does it matter? Who was the judge, Dad? Another silence, the longest yet. Thurston Briley, her father said, 29 years old, fresh on the bench, your mentor. The world tilted. Marlene sat in the dark, phone pressed to her ear, and felt everything she had believed rearrange itself. Briley, her mentor, her champion, the man who had recommended her for appellate panels, the man who had written her performance reviews, the man who had urged her to let the Hollister assault disappear, the man who had sentenced her uncle to 8 years in prison, the man who had known, all this time, exactly who she was. "Dad," she said, "did he know? Does Briley know I'm Marcus's niece?" "He knows. He's always known." "How can you be sure?" "Because he called me, Marlene. The week you were appointed to the bench. He called me and said he wanted me to know he remembered Marcus, that he hoped the family could move forward, that he would be watching over your career. And you didn't tell me. I thought I was protecting you. I thought if you knew, you'd never take the bench, and I wanted you to succeed where Marcus couldn't." Marlene closed her eyes. "I need to go," she said. "Marlene, I need to go, Dad. I'll call you tomorrow." She hung up, and she sat in the dark, alone, with the weight of 30 years of secrets pressing down on her chest. She understood now. Briley's mentorship, his glowing reviews, his protection, guilt. He had sentenced an innocent man, her uncle, and spent the next 30 years making amends to a niece who didn't know she was owed anything. And now, when she threatened to hold the system accountable, he wanted her to disappear. Not to protect the institution, to protect himself. Because if her case went forward, if discovery happened, if investigators started digging through courthouse history, they might find more than Corso's pattern of discrimination. They might find Briley's. Thursday morning, 14 days after the assault, Marlene arrived at the courthouse early. She parked 3 blocks away, as she had every day since the attack. She walked through the public entrance, nodded to the security guard, and took the elevator to the 5th floor. Internal Affairs, Investigator Osei's office. She knocked. "Come in." Renata was sitting behind her desk, surrounded by files. She looked up, read something in Marlene's face. "What happened?" Marlene closed the door behind her. "I need to expand the scope of the complaint." "Expand it how?" "I believe Chief Judge Thurston Briley has been influencing the handling of discrimination complaints within the courthouse for personal reasons. I believe he has used his position to suppress investigations and protect individuals whose misconduct might expose his own history." Renata's eyes widened. That's a serious allegation. It's an accurate one. Do you have evidence?" Marlene sat down. "I have 30 years of questions that were never asked. I have a pattern of complaints against Corso that were systematically dismissed. I have a case from '97 that connects Briley to my family, and I have the sense that someone inside this courthouse has been waiting a very long time for someone to finally start asking." Renata was very still. "The anonymous source," she said. "The person sending the envelopes. You think they know about Briley? I think they know everything. I think they've been building this case for years. And I think they chose me because I'm the only one who has both the standing and the motivation to see it through." Motivation? Briley sentenced my uncle to 8 years for a crime he didn't commit. He's been managing my career ever since, not as a mentor, but as a guardian of his own secrets. When I file this complaint, I'm not just challenging Corso. I'm challenging the system that protected both of them. Renata leaned back in her chair. "You understand what this means. If you go forward with this, you're not just filing a complaint. You're starting a war." "I know. A war you might not win. I know that too." Renata studied her for a long moment. "What do you need from me?" "I need you to open a parallel investigation into Briley's handling of the Corso complaints. I need you to subpoena his personnel records, his judicial conduct history, and any communications related to discrimination investigations over the past decade. And I need you to do it before he realizes what's happening. That's a tall order. That's justice." Another long pause. Then Renata nodded. "I'll make some calls." The 3rd anonymous envelope arrived that afternoon. It was waiting in Marlene's chambers when she returned from her meeting with Osei. Same plain manila, same lack of return address. Inside, a single photograph. 2 men shaking hands, young, smiling, standing in front of a sign that read, "Miami-Dade County Democratic Party, Annual Gala '96. One of the men was Thurston Briley, 30 years younger, full head of dark hair, already wearing the expression of a man destined for the bench. The other man was Vincent Corso, also younger, also smiling, also destined for something, though his path had led to a security badge instead of robes. Beneath the photograph, handwritten, "They've known each other since the beginning. The question is, who else knows?" Marlene stared at the photograph, 96. 1 year before her uncle's conviction. Briley and Corso, already connected, already moving through the same circles, already part of the same machinery that had crushed her uncle, the same machinery that had dismissed 3 complaints against Corso, the same machinery that was now trying to crush her. She turned the photograph over. On the back, another handwritten note. Different handwriting, older ink. "I tried to tell them, nobody listened, now it's your turn." And beneath that, a date, March 14th, 23. The same date as the first complaint against Corso, the same complaint that had been dismissed as insufficient evidence. Someone had been trying to expose this for years, someone who had given up when nobody listened, someone who was now handing the torch to Marlene. She looked at the handwriting, studied it. It was familiar. She had seen it before, on a case file, on a memo, on a document that had passed through her chambers years ago. She went to her filing cabinet, pulled out an old folder, compared the handwriting. Match. The handwriting belonged to court reporter Yolanda Fitch. Marlene found Yolanda in the break room on the 3rd floor. The court reporter was alone, stirring a cup of tea, staring out the window at the Miami skyline. "Ms. Fitch?" Yolanda turned. Her face was carefully neutral. "Judge Ashford, we need to talk." A pause. Then, "Not here." They walked to the stairwell. Yolanda checked both directions before speaking. "You found the photograph." "I found all of them. The complaints, the email, the photograph of Briley and Corso." Marlene kept her voice low. "You've been sending them." "Not all of them. Just the photograph. The rest came from someone else." "Who?" "I don't know. I received an envelope last year, right after I filed my complaint against Corso. Instructions on how to pass information without leaving a trail. I thought it was a trap at first, but then the documents started arriving. Documents I couldn't have accessed myself. Documents that proved what I had suspected for years. That Corso wasn't acting alone. That Corso was protected by someone powerful. Someone who had been protecting him since before I started working here. Briley." Yolanda nodded. "I saw them together, Judge Ashford, years ago, at a function. The way Briley spoke to Corso, not like a supervisor speaking to a subordinate, like an equal, like an old friend, like someone who owed him." "Owed him for what?" "I don't know, but I know it started in the 90s, before I was hired, before you took the bench. Whatever they're hiding, it goes back 30 years. Marlene thought about her uncle, about the conviction, about Briley's phone call to her father. "Ms. Fitch, do you know who else is involved? Who else has been sending documents?" Yolanda hesitated. "I have a guess." "Tell me." "The email you received. The one from Vance that was accidentally forwarded. It came from inside his firm, from someone with access to privileged communications. A whistleblower. A plant. Someone who's been embedded at Holland & Associates for years, waiting for the right case." Yolanda's voice dropped to barely a whisper. "Judge Ashford, I don't think you realize how big this is. I don't think you realize how many people have been waiting for someone like you to finally ask the right questions. Then why didn't anyone come forward sooner? Because we were afraid, because we didn't have power, because the people who tried got transferred, demoted, or worse." Yolanda's eyes were bright. "But you're different. You're a judge. You have standing. You have protection. And you have something none of us had." "What's that?" "Personal stakes. They destroyed your uncle. Now you get to destroy them." End of part 1. Marlene returned to her chambers. She closed the door. She sat at her desk. On the surface in front of her, the photograph of Briley and Corso, the anonymous notes, the FOIA responses, the case file from 97, 30 years of secrets, 30 years of silence, 30 years of a system protecting itself. And somewhere in that system, hidden among the clerks and reporters and administrative staff, a network of people who had been waiting for this moment. She picked up her phone, dialed Patty. The scope of this case just changed. Changed how? It's not just Corso anymore. It's not just the assault. It's the entire structure that enabled him, starting with Chief Judge Briley, going back 30 years. Marlene, I know what it is. I also know I can't do it alone. What do you need? I need to find out who sent the anonymous envelopes. I need to identify the whistleblower inside Holland and Associates. And I need to know who else has been waiting for someone to finally start this fight. A long pause. That could take months, years. I have time. Do you? Briley knows you're coming for him now. He's going to fight back. He's going to use everything he has. Marlene looked at the photograph, at Briley's young face, at the smile of a man who had built a career on other people's silence. Let him fight, she said. I've been preparing for this my whole life. And if you lose, then at least I tried. At least I didn't let them bury another complaint. At least I didn't let my uncle's memory disappear like everyone wanted. Silence. I'm with you, Patty said. Whatever it takes. Thank you. Marlene hung up, and she sat in the growing dark, surrounded by documents and secrets, waiting for the next move. Outside her window, the Miami skyline glittered. Somewhere in that city, Garrett Hollister was consulting with his attorney. Somewhere, Vincent Corso was reviewing his retirement options. Somewhere, Thurston Briley was making phone calls, pulling strings, preparing to protect a 30-year-old secret. And somewhere, hidden in the courthouse's endless corridors, the anonymous source was waiting to see what Marlene would do next, waiting to see if she was brave enough to follow the trail to its end. The first part of this story ends here, but the question that would drive everything that followed remained. If Briley sentenced her uncle, if Corso was there from the beginning, if they had been protecting each other for 30 years, who else knew, and what else were they hiding? The investigation moved like water through cracks in stone, slowly, persistently, finding every weakness in the walls that had been built to contain it. 3 weeks after the assault, Marlene sat in her chambers reviewing the formal discovery packet that Patty had assembled. The table before her was covered in documents, photographs, and transcripts. Each piece of evidence was tagged, dated, and cross-referenced. Each piece told part of a story that was larger than she had imagined. The body cam footage had arrived first. Patty had secured it through a court order, Judge Carolyn Reeves presiding, since Marlene had recused herself from all matters related to her own complaint. The footage was grainy, the audio tinny, but the content was damning. Timestamp 7:22 a.m. Badge number 4417. Officer Vincent Corso. The recording showed exactly what Marlene remembered. Corso approaching her, separating her from the Hollisters, asking for her statement, then canceling the dispatch before she could give one. But there was something else on the footage, something Marlene had not noticed in the moment. At 7:19 a.m., just before Corso arrived, a figure appeared at the edge of the frame. A man in a dark suit, standing near the elevator, watching. He did not approach, did not intervene, simply observed. And then, at 7:21, he made a phone call. The timestamp on Corso's radio, the moment he decided to cancel the dispatch, was 7:22. 1 minute later, someone had told Corso to stand down. Someone who had been watching from the shadows. The figure's face was not visible in the footage. The angle was wrong, the resolution too poor. But his silhouette was distinctive. Tall, silver-haired, carrying himself with the authority of a man who expected to be obeyed. Marlene knew that silhouette. She had seen it every day for 12 years. The dispatch logs confirmed the timeline. Marlene's 911 call had been logged at 7:18 a.m. Call ID 7422018. Bryn Hollister's call came 2 minutes later at 7:20. Call ID 7422019. Marlene's call came first, but the response went to Bryn. The dispatcher's notes read, Unit dispatched per caller 7422019. Caller 7422018 flagged as duplicate incident, no additional response required. Someone had marked her call as a duplicate. Someone had decided that the black woman's account was redundant, that the white woman's version was the only one that mattered. Patty traced the flag to a supervisor override. The supervisor's employee ID was redacted in the official record, but the timestamp was clear, 7:20 a.m. The same moment Bryn's call connected, the same moment that the figure in the dark suit made his phone call. It's coordinated, Patty said during their next meeting. The timing is too precise to be coincidence. Someone was watching you that morning, someone who knew you would be in that garage. The construction vehicles, Marlene said. They blocked the judge's lot, forced me to park in the public structure. Hollister and Sons Commercial Contracting. Garrett's company. Patty nodded slowly. What if it wasn't an accident? What if the construction was deliberately scheduled to force judges into the public garage? That's paranoid. Is it? Patty pulled out a document. I checked the construction permits. The work was scheduled to start next week. Someone moved it up by 7 days. The authorization came from the chief judge's office. Marlene felt the cold thing in her chest spread through her entire body. Briley scheduled the construction. Briley created the conditions. Whether he knew what would happen, Patty shrugged. That's what discovery is for. Timbe. The faux IA responses continued to arrive. 7 complaints against Vincent Corso over the past 5 years. 7 black women who had reported discriminatory treatment. 7 complaints marked resolved, no action required. But there was a pattern in the complaints that Marlene had not noticed before. Each woman had been in the courthouse for a specific purpose, not random visitors, not confused tourists. Each one had been there for a case that was later decided against them or their family members. The woman from March 2023, the first complaint, the one that had been sent anonymously, was the sister of a defendant in a drug possession case. Her brother had been convicted, sentenced to 12 years. The presiding judge, Thurston Briley. The woman from August 23, Patricia Okonkwo, Marlene's own attorney, had been at the courthouse representing a client in an employment discrimination case. The case was dismissed on summary judgment. The presiding judge, Thurston Briley. The woman from January 24, the defendant's mother, who had been blocked from entering a courtroom, was there for her son's sentencing hearing. Aggravated assault, 10 years. The presiding judge, Thurston Briley, 7 complaints, 7 cases, 7 decisions that had gone against black defendants or plaintiffs, and 1 judge whose name appeared on every single file. He's been using Corso as a filter, Marlene said, intimidating witnesses, harassing family members, creating hostile conditions that discourage people from attending hearings or supporting defendants. Renata Osei sat across from her in the Internal Affairs conference room. The investigator's face was carefully neutral, but her eyes betrayed something that might have been vindication. We suspected as much, Renata said, but we could never prove the connection. The complaints were always isolated incidents, different dates, different circumstances, different complainants. Nobody saw the pattern, because nobody was looking. Because the pattern was designed to be invisible, Renata opened a folder. I've been authorized to expand the investigation. Chief Judge Briley is now a person of interest. On what grounds? Obstruction of administrative proceedings, potential conspiracy to deprive citizens of civil rights under color of law, and, she hesitated, and what? Your uncle's case, State v. Marcus Ashford, 97, Marlene's breath caught. We pulled the file, Renata continued. The original case file, not the summary. There are irregularities. What kind of irregularities? The arresting officer's report was amended 3 times before trial. Each amendment added details that strengthened the prosecution's case, details that weren't in the original arrest narrative. That happens. It does, but the amendments were all authorized by the same supervisor. Renata slid a document across the table. Deputy Vincent Corso, Miami-Dade Sheriff's Office, 97, before he transferred to courthouse security. Marlene looked at the document, at Corso's signature, at the date, 3 weeks before her uncle's trial. He was a deputy sheriff? For 6 years. He transferred to courthouse security in 2002, the same year Briley was appointed chief judge. They have been working together for over 20 years. At minimum, Renata closed the folder. Judge Ashford, I have to be honest with you. This investigation is going to take time, years, potentially, and there's no guarantee of outcome. Briley has powerful allies. Corso has union protection. The evidence we have is circumstantial, compelling, but circumstantial. What are you telling me? I'm telling you that if you want quick resolution, you won't find it here. The system protects itself. Even when we expose the rot, the system finds ways to survive. Marlene thought about her uncle, about the 8 years he had lost, about the family gatherings where his name was never spoken. I'm not looking for quick resolution, she said. I'm looking for the truth. Then we'll find it, however long it takes. The system protects itself, but sometimes One person can crack the foundation. Keep watching. See, 4 weeks after the assault, the criminal charges were filed. State of Florida versus Garrett Hollister and Bryn Hollister. Case number 24CF8891. Judge Carolyn Reeves presiding. The charging document listed 3 counts. Count 1, battery, Florida statute 78403. Maximum penalty, 1 year imprisonment, $1,000 fine. Count 2, battery on a judicial officer, Florida statute 784.035. Enhanced felony. Maximum penalty, 5 years imprisonment, $5,000 fine. Count 3, filing false police report, Florida statute 837.05, misdemeanor, maximum penalty, 1 year imprisonment, $1,000 fine. The enhancement, count 2, was the key. Under Florida law, assaulting a judicial officer carried significantly harsher penalties than simple battery. The statute was designed to protect the integrity of the justice system, to ensure that judges could perform their duties without fear of retaliation. Garrett Hollister had not known he was assaulting a judge. That ignorance would not protect him. The arraignment was scheduled for 10 a.m. on a Tuesday morning. Marlene was not present. She could not be. She was a witness in the case, not a participant. But she watched the proceedings through the courthouse closed-circuit system, standing in an empty conference room on the 4th floor. Garrett and Bryn stood at the defense table, their attorney Delmore Vance between them. They looked diminished somehow, smaller. The courtroom's fluorescent lights washed the color from their faces. "How do the defendants plead?" Judge Reeves asked. Vance spoke for them. "Not guilty, Your Honor. We request reasonable bail and object to the enhanced charges under count 2. The defendants had no knowledge that the alleged victim was a judicial officer. Ignorance is not a defense to the enhancement, counselor. The statute is clear. We intend to challenge the constitutionality of the statute as applied, Your Honor. You may file your motion. Bail is set at $50,000 each, cash or bond. Defendants will surrender their passports and refrain from any contact with the victim or witnesses in this case." The gavel fell. And Marlene watched the Hollisters being led away to process their release, their faces pale, their confidence shattered. It was not satisfaction she felt. It was something harder to name. So, the discovery phase lasted 4 months. 4 months of depositions, document requests, and legal maneuvering. 4 months of Vance filing motion after motion, to dismiss, to suppress, to compel, to delay. 4 months of Patty responding, countering, pushing back. During those 4 months, Marlene continued to sit on the bench, continued to hear cases, continued to perform the duties she had sworn to uphold. But something had changed. The courthouse felt different now. The familiar corridors seemed to hold shadows she had never noticed. The colleagues who nodded to her in hallways, did they know? Had they always known? Were they part of the system that had protected Briley and Corso? Or were they, like her, simply blind to what had been happening beneath the surface? She found herself watching people more carefully, noticing details. The security guard who always seemed to be near her courtroom. The clerk who handled her files with unusual attention. The bailiff who had nodded to her that day in the hallway. The deep, knowing nod that had seemed significant even then. One afternoon, 6 weeks into the discovery phase, that bailiff approached her. His name was Theodore Marsh, 30 years on the job, 2 years from retirement. "Judge Ashford," he said, his voice low. "May I speak with you privately?" They stepped into an empty jury room. Theodore checked the door twice before speaking. "I worked with Corso when he first transferred in," he said. 2002. I was there. What did you see?" "I saw him take orders, not from his supervisors, from someone else. Phone calls he would take in private. Instructions he would follow without question." Theodore's hands were clasped in front of him, the knuckles white. "I never knew who was on the other end, never asked. But I knew it wasn't right." "Why are you telling me this now?" "Because you're the first person who's asked the right questions." He met her eyes. "And because I'm tired of pretending I don't see what I see." "Would you testify?" A long pause. "If it comes to that," he said finally, "yes, I would testify." Among missing, the witnesses began to emerge. One by one, like figures stepping out of fog, they came forward. The women who had filed complaints against Corso, the clerks who had noticed irregularities, the attorneys who had suspected bias but had no way to prove it. Each one had a story. Each story added a thread to the tapestry Marlene was weaving. Patricia Okonkwo, Patty, testified at her own deposition about her 23 complaint. How Corso had demanded 3 forms of identification when she entered the building. How he had made her open her briefcase and remove every item. How he had commented that she didn't look like a lawyer. "What did you do?" the deposing attorney asked. "I filed a complaint. It was marked inconclusive. I was told there was no evidence of discriminatory intent." "Did you pursue the matter further?" "No. I had clients to represent, cases to file. I told myself it was an isolated incident." Her voice hardened. "I was wrong." The woman from March 23, the first complaint, was named Denise Williams. Her brother had been convicted of drug possession with intent to distribute, sentenced to 12 years by Judge Thurston Briley. She testified that Corso had stopped her in the lobby on the day of her brother's sentencing hearing, had demanded to see her ID, had told her she was making a scene when she asked why, had delayed her long enough that she missed the first 20 minutes of her brother's hearing. "Did you file a complaint?" "I tried. The intake officer told me it would take weeks to process, that by the time anything happened, my brother's case would be over." Denise's eyes were dry, but her voice shook. "I didn't know what else to do, so I let it go." "And your brother?" 12 years. He's been in prison for 3.5. He has a daughter who's never seen him outside of visiting hours. Said the mother from January 24, the one who had been blocked from entering her son's courtroom, was named Barbara Chen. Her son had been convicted of aggravated assault, sentenced to 10 years. She testified that Corso had physically stepped in front of her when she tried to enter the courtroom, had told her the gallery was full when she could see empty seats through the window, had threatened to have her arrested for trespassing if she didn't leave. Did anyone intervene? A bailiff came out eventually. Theodore Marsh. He told Corso to let me through. Barbara's face tightened. But by then, my son had already been sentenced. I didn't get to see him before they took him away. "Did you file a complaint?" "I filed, and I got a letter 6 weeks later saying my complaint had been resolved. No explanation, no apology, nothing." 7 complaints, 7 women, 7 stories of being made to feel like they did not belong in their own courthouse. And 1 security supervisor whose actions had been protected over and over by a system designed to look the other way. Boss, the parallel investigation into Briley moved more slowly. Renata Osei had been careful. Too careful, Marlene sometimes thought. Every step was documented. Every procedure followed. Every potential objection anticipated and addressed. "We only get 1 shot at this," Renata explained during one of their meetings. "If we move too fast, if we cut corners, his attorneys will find a way to dismiss everything. We have to build an airtight case. And if he retires before we're ready, then we pursue him as a private citizen. The statute of limitations on civil rights violations is generous. That's not justice. That's letting him escape. That's reality." Renata's voice was not unkind. "Judge Ashford, I understand your frustration, but the same rules that protect Briley also protect the victims we're trying to help. Due process isn't just for defendants. It's for everyone." Marlene thought about her uncle, about the process that had failed him 30 years ago. Sometimes due process is just another word for delay. Sometimes it is, and sometimes it's the only thing standing between accusation and conviction. Renata paused. "Would you want to be convicted without it?" Marlene did not answer, but she understood. Justice moves slowly, but it moves. Don't give up. 5 months after the assault, the plea negotiations began. Vance approached the prosecutor, ASA Marcus Layton, with an offer. The Hollisters would plead guilty to misdemeanor battery. They would accept community service, probation, and a fine. In exchange, the felony enhancement under count 2 would be dropped. "The evidence supports enhanced charges," Layton told Marlene during a victim consultation meeting. "We can prove battery on a judicial officer. We can prove they filed a false report. But trials are uncertain, juries are unpredictable, and Vance is already laying groundwork for a defense based on lack of knowledge, arguing that the enhancement requires the defendant to know the victim's status. Does it? The statute is ambiguous. No appellate court has ruled on the issue. If we go to trial and lose on count 2, the Hollisters walk away with a misdemeanor conviction. Maybe probation, maybe less. And if we take the plea, they're convicted felons. The battery charge stays on their record. They do community service, they serve probation, and if they violate, Leighton met her eyes. If they violate, we can reinstate the enhanced charges. The clock starts over. Marlene considered it. What do you recommend? I recommend we make them sweat a little longer. File some additional motions. Let them see what discovery looks like. Then, if they still want to deal, we negotiate from strength. And the message that sends? The message is that assaulting anyone in this courthouse, judge, clerk, janitor, has consequences. Maybe not the consequences we want, but consequences nonetheless. The sweat worked. 6 weeks later, Vance returned with a revised offer. The Hollisters would plead no contest to battery on a judicial officer, the felony charge. They would accept 200 hours of community service, 3 years of probation, and a $10,000 fine. The false report charge would be dropped. It was not everything, but it was something. Marlene sat in the consultation room, reading the proposed plea agreement. Patty sat beside her, silent. "What do you think?" Leighton asked. "I think it's insufficient. It's a felony conviction. They'll have to disclose it on every job application, every background check for the rest of their lives. They assaulted me. They lied about it. They tried to destroy my reputation." Marlene's voice was steady, but her hands trembled slightly. A felony conviction and community service doesn't erase that. No, it doesn't. Leighton leaned forward. But it's a foundation. The Hollisters are convicted. Corso is under investigation. Briley is a person of interest. The case you're building, the larger case, depends on this conviction. Without it, everything else falls apart. Patty spoke for the first time. "He's right, Marlene. This isn't the end. It's the beginning." Marlene looked at the plea agreement, at the sterile legal language that reduced her experience to clauses and conditions. "I want them to apologize," she said. "In court, on the record, I want them to admit what they did." Leighton nodded. "I'll make it part of the deal." The plea hearing was held on a Thursday afternoon, 7 months after the assault. Courtroom 9C was packed. Reporters filled the gallery. Camera crews waited outside. The story had leaked somehow. Black judge assaulted in courthouse garage. Attackers plead guilty. And the media had descended. Marlene sat in the first row of the gallery, not at the prosecution table, not on the bench, just another citizen watching justice unfold. Judge Reeves called the court to order. "The court has reviewed the proposed plea agreement in the matter of State of Florida versus Garrett Hollister and Bryn Hollister, case number 24 CF 8891. Before accepting the plea, the court will hear from the defendants. Mr. Hollister, do you understand the charges against you?" Garrett stood. He was thinner than Marlene remembered. The months of legal proceedings had worn on him. "Yes, Your Honor." "And do you understand that by pleading no contest, you are waiving your right to a trial by jury?" "Yes, Your Honor." "The plea agreement requires you to make a statement acknowledging your conduct. Are you prepared to do so?" Garrett's attorney whispered something. Garrett nodded. "Yes, Your Honor." Judge Reeves gestured. "Proceed." Garrett turned toward the gallery. His eyes found Marlene. "On the morning of—" He cleared his throat. "On the morning in question, I encountered a woman in the courthouse parking garage. I assumed, based on her appearance, that she did not belong there. I confronted her. When she did not respond the way I expected, I became aggressive. I grabbed her arm. I pushed her against a wall." His voice faltered. "I didn't know she was a judge, but that's not the point. The point is that I treated her like she was less than human because of how she looked, because of assumptions I made, assumptions that were wrong." He paused, swallowed. "I'm sorry for what I did, for what I assumed, for the harm I caused." He sat down. Bryn stood next. Her statement was shorter, more rehearsed. She admitted to calling 911 with a false report. She apologized for describing Marlene as suspicious and aggressive when she was neither. "I let my prejudice speak for me," Bryn said. "I'm ashamed of that." Judge Reeves accepted the pleas. "Mr. and Mrs. Hollister, you have pleaded no contest to battery on a judicial officer, a felony under Florida law. The court sentences you each to 200 hours of community service, to be completed within 18 months. You are placed on probation for a period of 3 years. You will pay a fine of $10,000 each to be deposited in the court's Victim Assistance Fund. You will have no contact with Judge Marlene Ashford or any witnesses in this case." The gavel fell. This court stands adjourned. After the hearing, Marlene stood in the courthouse lobby, surrounded by people who wanted to shake her hand, congratulate her, tell her how brave she was. She felt none of it. She felt only the weight of what remained undone. The Hollisters were convicted, but Corso was still employed, suspended, yes, but still drawing a paycheck while his union grievance wound through the system. Briley was still chief judge, a person of interest in an investigation that might take years to conclude. The systemic failures that had enabled the assault remained largely intact. Patty found her near the elevators. "You should be proud," Patty said. "This is a victory. It's a partial victory. All victories are partial. That's how justice works. One step at a time." Marlene watched the reporters filing out, already composing their headlines, already moving on to the next story. "The investigation into Briley," she said. "How long?" "Renata thinks 6 months minimum, maybe longer. And if he retires before it concludes? Then we pursue him as a civilian. The process continues. But the leverage is gone. If he's not chief judge, the institutional pressure disappears." Patty was quiet for a moment. "There's something else," she said finally. "Something Renata found." "What?" "Your uncle's case file, the original one, from '97. There are documents missing." "What kind of documents?" "Witness statements. 3 witnesses who were interviewed by police but whose testimony never appeared at trial. Their statements were removed from the file sometime between the preliminary hearing and the trial date. Who removed them? Unknown, but the removal was authorized by the supervising deputy on the case." "Corso," Patty nodded. "And the witnesses?" "2 of them are dead, natural causes both. The third," Patty hesitated. "The third is alive. Her name is Gloria Patterson. She's 74 years old, living in a nursing home in Homestead, and she's willing to talk." Gloria Patterson had been a housekeeper in '97. She had worked for a family in Coral Gables, the same family whose son had been arrested for drug possession the same week as Marcus Ashford. "I saw what happened," Gloria said. Her voice was thin but clear. "I was there when the police came. I saw them plant the drugs." Marlene sat beside her hospital bed, a recorder on the table between them. Patty stood by the window, taking notes. "What exactly did you see?" "The officers came to the house, 3 of them. They said they had a tip about drugs, but I knew that family for 15 years. Good people, church people. There were no drugs in that house." "What happened next?" "They searched the garage, found nothing. Then one of them, young fellow, dark hair, mean eyes, he went back to the car. Came back with a bag, a plastic bag with something white inside. And then? Then he went into the garage by himself. Came out a minute later and called the others over. Said he found something." Gloria's hand trembled on the bedsheet. "That bag wasn't there before. I know what I saw. Did you tell anyone?" "I tried. I talked to a detective, told him what I saw. He wrote it all down, said they would look into it. And nothing. Nobody ever called me back. Nobody asked me to testify. When I tried to contact the detective again, he said my statement had been lost, said I must have been mistaken about what I saw." "Do you remember the detective's name?" Gloria's eyes focused on something far away. "Corso," she said. "His name was Vincent Corso." The pieces were coming together. Corso had been involved in the original arrest. Corso had supervised the evidence. Corso had removed witness statements that might have exonerated Marcus Ashford. And 30 years later, Corso was still protecting the same system, still harassing black visitors, still dismissing complaints, still following orders from someone whose identity remained hidden in shadow. But the shadow was shrinking. The photograph from '96, Briley and Corso shaking hands at a political fundraiser. 2 young men at the beginning of their careers, already connected, already building the network that would protect them for decades. The construction schedule, moved up by 7 days, forcing judges into the public garage, authorization from the chief judge's office, the figure on the body cam footage, tall, silver-haired, making a phone call 1 minute before Corso canceled the dispatch. It all pointed to Briley, but pointing was not proving. "We need more," Renata said during their next meeting. "Gloria Patterson's testimony is compelling, but it's 30 years old. Defense attorneys will tear it apart. We need documentation. We need records." The records were destroyed. Some of them, but not all. Renata slid a folder across the table. "I found something in the archives. A memo from '98, 1 year after your uncle's conviction. Internal review of the Ashford case. Author unknown. The signature page is missing. But the content is interesting. Marlene opened the folder. The memo was 6 pages long, densely typed, full of legal jargon. But certain passages were highlighted. Procedural irregularities in the handling of evidence, witness statements removed without proper authorization, recommendation for further review, and on the final page, this review concludes that significant questions remain regarding the integrity of the prosecution's case against Marcus Ashford. However, given the defendant's conviction and the expiration of direct appeal deadlines, no further action is recommended at this time. The matter is closed. Signed, Administrative Review Committee. No names, no accountability, just a quiet acknowledgement that something had gone wrong, and a decision to do nothing about it. They knew, Marlene said. They knew in '98 that my uncle's conviction was questionable, and they buried it. They buried a lot of things, Renata said, but buried things have a way of coming back up. What do you need from me? I need you to be patient. The Briley investigation is ongoing. We're building a case for the Judicial Qualifications Commission, pattern of misconduct, abuse of authority, possible conspiracy, but it takes time. How much time? I don't know, months, maybe years. Renata's expression softened. Judge Ashford, I understand this is personal for you, your uncle, your family, everything that was taken from them. But if we rush this, if we cut corners, Briley walks. He retires with his pension, his reputation, his secrets intact. Is that what you want? I want justice. Then let us do our job. Let the process work. So, the process worked. Slowly, painfully, but it worked. 9 months after the assault, the internal affairs investigation into Vincent Corso concluded. The findings were damning, a pattern of discriminatory behavior spanning more than a decade. Multiple complaints dismissed without proper investigation. Evidence of coordination with courthouse officials to minimize accountability. The recommendation, termination. Corso's union filed an immediate grievance. The matter was referred to arbitration. The timeline stretched into uncertainty. But the findings were public now. The pattern was documented. And for the first time in 11 years, Vincent Corso was not protected by the shield of institutional silence. 10 months after the assault, Chief Judge Thurston Briley announced his retirement. The press release cited personal reasons and a desire to spend more time with family. It made no mention of the ongoing investigation, the scrutiny that had intensified in recent months, the questions that had no good answers. Briley's last act as Chief Judge was to issue a public statement acknowledging the unfortunate incident involving Judge Marlene Ashford and announcing new implicit bias training for all courthouse security personnel. The 11th Judicial Circuit, the statement read, is committed to ensuring that every person who enters our facilities is treated with dignity and respect. We condemn any conduct that falls short of that standard, and we are implementing enhanced protocols to prevent future incidents. The training was scheduled to begin pending budget approval. 4 words that could mean anything. 4 words that meant, in practice, nothing. Retirement is not accountability. Remember that. 11 months after the assault, the Department of Justice opened a preliminary inquiry into the Miami-Dade Courthouse Security Division. The letter arrived on a Tuesday afternoon. Marlene read it in her chambers, alone. This office is examining whether the policies and practices of the Miami-Dade Courthouse Security Division constitute a pattern or practice of discriminatory enforcement under 34 U.S.C. Section 11601. Your complaint, along with supporting documentation, has been included in the materials under review. It was not an investigation, not yet, but it was a beginning. 12 months after the assault, the arbitration ruling came down. Vincent Corso was suspended without pay for 90 days. He would be required to complete 16 hours of sensitivity training before returning to duty. His personnel file would include a formal reprimand. He was not terminated. The union had argued successfully that the evidence, while troubling, did not meet the standard for termination under the collective bargaining agreement. Corso had followed procedures, flawed procedures perhaps, but procedures nonetheless. The complaints against him were isolated incidents that did not demonstrate a pattern of intentional discrimination. Marlene read the ruling and felt something break inside her. Not break like shattering, break like a bone that heals wrong, break like something that would never be quite right again. 90 days, 11 years of harassment, intimidation, and discrimination, and the punishment was 90 days. She found Yolanda Fitch in the break room that evening. The court reporter was packing a box. "They transferred me," Yolanda said before Marlene could ask. "Night court, effective immediately." "That's retaliation. That's the system." Yolanda's voice was flat. "I knew the risk when I came forward. I knew what they would do. I can file a complaint, and what? Add another piece of paper to another pile? Hope that someone, somewhere, actually does something?" Yolanda shook her head. "I don't regret helping you, Judge Ashford. What you're doing matters, but I'm tired. I've been fighting this system for 20 years, and it's still standing. Maybe it always will be." She picked up her box. "Good luck," she said. "You're going to need it." She walked away, and Marlene stood alone in the empty break room, surrounded by the hum of vending machines and the silence of a building that had absorbed 30 years of secrets. 13 months after the assault, Marlene returned to her chambers to find an envelope on her desk. It was from the Judicial Qualifications Commission. She had been expecting it for weeks, the formal notification of the investigation's status, the next steps in the process, the timeline for Briley's accountability. She opened it. The letter was brief. After thorough review of the materials submitted, the Judicial Qualifications Commission has determined that insufficient evidence exists to proceed with formal charges against former Chief Judge Thurston Briley. While the Commission acknowledges the concerns raised by multiple complainants, the available documentation does not meet the evidentiary standard required for disciplinary action. This matter is now closed. Closed? 30 years of cover-ups, 30 years of protection, and the matter was closed. Marlene set the letter down. She thought about her uncle, still serving time for a crime he might not have committed. She thought about Gloria Patterson, whose testimony had been ignored for 3 decades. She thought about the 7 women whose complaints had been dismissed, the witnesses who had come forward only to be transferred or silenced, the system that had absorbed every blow and emerged unchanged. She thought about Briley, somewhere in Florida, enjoying his retirement, his pension, his reputation, and she felt something new. Not despair, not defeat. Something colder, something harder, determination. The same day she received the Commission's letter, Marlene filed a federal civil rights lawsuit. The defendant, Thurston Briley, individually and in his former capacity as Chief Judge of the 11th Judicial Circuit. The claim, conspiracy to deprive citizens of their civil rights under color of law, in violation of 42 U.S.C., Section 1983. The evidence, everything she had gathered over the past 13 months, the complaints, the witness statements, the documents, the patterns, the connections. The Commission might have closed its investigation, but Marlene was just beginning hers. 14 months after the assault, Garrett Hollister violated his probation. The notice came from his probation officer, a routine report flagged for attention because of the high-profile nature of the case. Hollister had missed his second mandatory check-in. His community service hours were incomplete. He had failed to pay the second installment of his fine. Under the terms of his plea agreement, the felony charges could be reinstated. The clock had started over. Marlene read the notice in her chambers. Outside her window, the Miami skyline glittered in the afternoon sun. Construction cranes dotted the horizon, building new towers on foundations she could not see. Her phone buzzed. A text from ASA Layton. "Heard about Hollister. Hearing scheduled for next month. Thought you should know." She typed a response. "Thank you. Keep me informed." She set the phone down, and she allowed herself, for the first time in 14 months, something that felt almost like hope. 15 months after the assault, Marlene parked in the public garage. Level 2, space 247, the same space where it had all begun. It was early, 5:52 a.m., and the garage was nearly empty. Her footsteps echoed off the concrete as she walked toward the elevator. A security guard approached. New uniform, new face, name tag that read Williams. "Morning, Judge Ashford," he said. "Morning." He did not ask for ID, did not block her path, did not question why she was there. Small thing. Everything and nothing. She pressed the elevator button, waited. The doors opened. She stepped inside. And as she rose through the building, past the lobby, past the courtrooms, past the offices where people were just beginning to arrive. She thought about everything that had happened, everything that had changed, everything that remained the same. Garrett Hollister was facing new charges. Vincent Corso was suspended, counting down the days until his return. Thurston Briley was retired, protected by a system that had failed to hold him accountable. The DOJ inquiry was ongoing, preliminary, tentative, uncertain. The civil lawsuit was filed, years away from resolution, assuming it survived the inevitable motions to dismiss. The training program was implemented, pending budget approval, effectiveness unknown. And somewhere in the building, hidden in the endless corridors and quiet offices, the people who had sent the anonymous envelopes were still watching, still waiting, still hoping that someone would finally crack the foundation. Marlene reached her floor. The doors opened. She stepped out into the hallway, walked to her chambers, opened the door. On her desk, a new envelope waited. Plain, manila, no return address. She opened it. Inside, a single sheet of paper, a photograph. The photograph showed a filing cabinet drawer, pulled open. Inside the drawer, dozens of folders, each one labeled with a name and a date. The visible labels read, Williams D., 23 Okonkwo P., 23 Chen B., 24 Ashford M., 24, and beneath the photograph, handwritten, there are more, many more. The drawer is just the beginning. And below that, a new instruction. Ask about the basement, room B7, what Briley left behind. Marlene stared at the photograph, a filing cabinet, folders, names, dates, a record of every complaint, every victim, every person the system had silenced, hidden somewhere in the courthouse basement, left behind by a man who thought his secrets would stay buried. She picked up her phone, called Renata. There's something in the basement, she said. Room B7. I think you need to see it. A pause on the line. How do you know? Someone told me. Someone who's been helping me from the beginning. The anonymous source. Yes. Another pause. Longer this time. I'll meet you there in 20 minutes. Room B7 was at the end of a long corridor, past the mechanical rooms and the storage areas, in a part of the basement that most courthouse employees had never seen. The door was locked. Renata had brought a maintenance worker with a master key. The room was small, maybe 15 feet square, and filled with filing cabinets. Dozens of them, gray metal, institutional, unmarked. Marlene opened the nearest drawer. Folders, hundreds of folders, each one containing a complaint, a witness statement, a piece of evidence that had been removed from the official record. 30 years of secrets, 30 years of silence, all of it here, in this room, waiting to be found. This is... Renata's voice trailed off. This is everything, Marlene said. Everything Briley wanted to hide. Everything he thought would never be found. She pulled a folder at random, opened it. The name on the label, Ashford, Marcus L. Her uncle's file, inside, the witness statements that had been removed before trial, Gloria Patterson's testimony, 2 others, all of them describing what they had seen, all of them ignored. And beneath the statements, a handwritten note. Per TB, removed from official file, not relevant to prosecution. TB, Thurston Briley, Sundayzik. The truth doesn't disappear. It waits. Sometimes for 30 years. The discovery of Room B7 changed everything. Within a week, the Judicial Qualifications Commission reopened its investigation. Within a month, the DOJ upgraded its preliminary inquiry to a formal pattern or practice investigation. Within 3 months, federal agents had cataloged more than 400 complaints that had been improperly handled, dismissed, or buried over a 30-year period. Thurston Briley was indicted on 12 counts of conspiracy, obstruction of justice, and deprivation of civil rights under color of law. His trial would not begin for another 18 months, but the indictment was enough. The system that had protected him for 3 decades had finally, irrevocably, cracked. The end came quietly, not with a dramatic courtroom confrontation, not with a tearful confession, not with the kind of catharsis that movies promised and reality rarely delivered. It came with paperwork, with depositions, with the slow, grinding machinery of justice doing what it was designed to do, imperfectly, incompletely, but doing it nonetheless. Vincent Corso resigned before his 90-day suspension ended. He took early retirement, forfeiting a portion of his pension in exchange for the department dropping its termination proceedings. He moved to a small town in the Florida Panhandle. Nobody heard from him again. The Hollister's probation violation hearing resulted in the reinstatement of the enhanced charges. Garrett pleaded guilty to avoid trial. He was sentenced to 18 months in state prison, reduced from the maximum 5 years, but prison nonetheless. Bryn received an additional year of probation and 500 hours of community service. The DOJ's pattern or practice investigation resulted in a consent decree requiring the Miami-Dade Courthouse Security Division to implement new policies, submit to federal monitoring, and report quarterly on complaint handling and resolution. The monitoring period, 5 years, long enough to make a difference, maybe. Marlene's civil lawsuit against Briley was settled out of court. The terms were confidential, but the settlement included a formal acknowledgement of wrongdoing, something Briley's attorneys had fought against until the very end. It also included a contribution to a fund for wrongful conviction victims, named after Marcus Ashford. Marcus himself had died in prison 3 years before Marlene's assault. Heart attack, 57 years old. He never knew that his niece had become a judge. He never knew that she had spent 14 months fighting to clear his name. He never knew that she had won. On the second anniversary of the assault, Marlene stood in her chambers, looking out at the Miami skyline. The construction cranes were gone now. New buildings stood where empty lots had been. The city had changed, as cities do, without asking permission. On her desk, a framed photograph. Her uncle Marcus, young and smiling, standing beside her father at a family gathering in 1985. Before the arrest, before the conviction, before 30 years of silence. Beside the photograph, a letter, handwritten on courthouse stationery. Judge Ashford, I never got to thank you properly. What you did, what you risked, it mattered. Not just to me, to everyone who's been waiting for someone brave enough to ask the right questions. The system is still standing. Maybe it always will be. But it's different now. Cracked, less certain of itself. And that's because of you. I'm retiring next month. 22 years in this building. 22 years of watching things I couldn't change. But I watched you change them. Thank you for that. YF. Yolanda Fitch. The woman who had sent the first envelope. The woman who had been transferred to night court for her trouble. The woman who had kept faith when faith seemed foolish. Marlene folded the letter carefully, placed it in her desk drawer beside 12 years of similar notes she had never mentioned to anyone. The phone on her desk buzzed. Judge Ashford, your 9 o'clock is here. Send them in. She straightened her robes, adjusted the photograph of her uncle so it faced the door, took a breath. The door opened. A young woman entered, early 20s, nervous, clutching a folder of documents. Behind her, an older woman who might have been her mother. Judge Ashford, the young woman said, thank you for seeing us. What can I do for you? I want to file a complaint about something that happened to me in the parking garage. A security guard. He said I didn't belong here. He demanded ID. He threatened to have me arrested. Marlene looked at her face, at the fear and anger and determination that flickered behind her eyes. Tell me everything, she said. The young woman began to speak, and Marlene listened, as she always listened, as she would always listen, for as long as there were stories that needed telling, and systems that needed challenging, and people who needed someone, anyone, to believe them. Outside the window, the sun rose over Miami. Inside the chambers, justice, imperfect, incomplete, but justice nonetheless, continued its slow, stubborn work. Epilogue. 6 months later, the morning was quiet. Marlene parked in the judge's reserved lot. It had been repaired months ago, the construction long finished, and walked through the private entrance. The security guard nodded as she passed. New face, new protocols, new training, small changes, everything and nothing. Her chambers were warm with morning light. On her desk, the usual stack of files. The usual cup of coffee, the usual routine of a life built on procedure and precedent, and something new. An envelope. Plain, manila, no return address. She opened it. Inside, a single sheet of paper, a news clipping dated 3 days earlier. Former Chief Judge Briley pleads guilty to federal charges. Thurston Briley, 72, former Chief Judge of the 11th Judicial Circuit, pleaded guilty Thursday to 3 counts of conspiracy and obstruction of justice in connection with a decades-long scheme to suppress civil rights complaints within the Miami-Dade court system. Under the terms of the plea agreement, Briley will serve 18 months in federal prison and pay restitution of $500,000 to victims of the scheme. He has also agreed to cooperate with ongoing investigations into other court officials who may have been involved. This case demonstrates that no one is above the law, said the U.S. Attorney in a statement. When public officials abuse their positions to harm the citizens they are sworn to serve, they will be held accountable. Beneath the clipping, handwritten in familiar script, it took 30 years, but we got there. Thank you, Judge Ashford, for everything. A friend. Marlene set the clipping down. She thought about her uncle, about Gloria Patterson, about Yolanda Fitch and Denise Williams and Barbara Chen and all the other women whose complaints had been buried in a basement room for decades. She thought about Garrett and Bryn Hollister, serving their sentences, facing the consequences of assumptions they had never examined. She thought about Corso, somewhere in the Panhandle, living with whatever remained of his conscience. And she thought about herself, about the woman who had walked into a parking garage 2.5 years ago, expecting nothing more than an ordinary Tuesday morning. The system was still standing, but it was different now, cracked, exposed, held accountable, imperfectly, incompletely, but accountable nonetheless. And that, Marlene understood, was how change happened. Not with explosions, not with revolutions, with cracks, one crack at a time, until the whole structure had to be rebuilt. She picked up the first file on her desk, opened it, began to read. Outside her window, the city continued its endless construction, new buildings rising, old foundations shifting, and somewhere in the courthouse basement, room B7 stood empty now, its secrets cataloged, its files distributed to investigators and attorneys and victims who had waited 30 years to know the truth. The room was just a room now, but the stories it had contained would echo for generations. Justice, Marlene had learned, was not a destination. It was a direction, and she would keep walking toward it, one step at a time, for as long as she had breath to walk. The phone buzzed. "Judge Ashford, your first hearing is ready." "On my way." She stood, adjusted her robes, walked to the door, and Marlene Ashford, judge survivor, advocate, stepped into another ordinary day, knowing that ordinary days were where the real battles were fought and won.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.